Brother has joined.
जी लॉर्डशिप।
स्क्रीन पे सबको नजर नहीं आ रहा। ब्रदर ज्वाइन किए हैं क्या? म्यूट है आपका, म्यूट।
जी ज्वाइन किए हैं लॉर्डशिप, देख रहे थे अभी।
स्क्रीन पे नजर आ रहे हैं?
नहीं स्क्रीन पे तो नजर नहीं आ रहा लॉर्डशिप, इसमें देख लेते हैं। अभी ज्वाइन नहीं की, अभी नहीं कनेक्ट।
कोई बात नहीं।
कुछ इशू होगा लॉर्डशिप, क्या कि ज्वाइन किए थे लॉर्डशिप।
अब ज्वाइन किए। गुड मॉर्निंग ब्रदर। आप कोर्ट में हैं?
म्यूट
म्यूट है आपका, म्यूट।
हाँ एक्चुअली आज सेकंड हाफ में इसके बाद रिवीजन रहता है।
सिंगल है, अच्छा।
जी जी सर।
तो लेट अस स्टार्ट।
From the Delhi College list under the heading for orders with defect. Item 1, first appeal number 323 of 2019, Mr. Onish Ranjan Misra for the appellant.
May I please? Two defects were there, minutes.
Yes.
One with regard to limitation notes for the same I filed interlocutory application notes. And
Two are
one
still left.
there were a delay of 74 days minutes for the same I have filed interlocutory application.
2 and 3 are still left, perhaps.
No, minutes. For two is with regard to limitation. For the same, I have filed interlocutory application notes, and 3 is with regard to certificate notes that has been filed on 7th of April itself, minutes.
The defects are not relating to that. Defects is, as pointed out by stamp report of 6th March.
लॉर्डशिप डिफेक्ट नंबर 3 सर्टिफिकेट के लिए है लॉर्डशिप, डिफेक्ट नंबर 3 और डिफेक्ट नंबर 1 पार्टली रिमूव होगा।
Partly removed, or defect number 2 and 3 of 8th January 20 stand still. तो अब देख लीजिए, एक वीक में कर लीजिए छोटा छोटा डिफेक्ट।
2 weeks minutes by way of last chance minutes. I'll remove minutes.
2 weeks.
2 weeks minutes.
By way of last tender.
Much obliged. Much obliged.
Item number 2, WPS number 1132 of 2020, Mr. Jitesh Kumar for the petitioner, Mr. Gautam.
Yes, my lord. Kindly grant me 3 weeks time to remove the defect, my lord.
3 weeks.
Yes, my lord. Because next week is vacation, my lord. 4 days.
3 weeks peremptory.
I am appearing on behalf of Union of India.
Give your slip to the court
My
master.
lord.
What
Much
is your
obliged.
good name?
Rani Jaluka, AC2 ASGI.
Send your appearance slip. ये आइटम 4, 5, 6 पहले जरा कॉल कर लीजिए तो.
Item 4, first appeal number 49 of 2021, Mr. Lukesh Kumar for the appellant.
So there is limitation of 229 days in first appeal. This is against the divorce dismissal of divorce. We have filed this first appeal.
So earlier time was granted to you. There are still defects remaining. You have filed limitation petition perhaps. Other defects are still there.
Several defects, 3, 2, 8, and 11 and 12.
2 weeks peremptory to remove the
As
remaining surviving defects.
Item 5, WPT number 842 of 2021, Mr. Dipsina for the petitioner, Mr. P.S. Patil for the
My lord, in this case, I am praying for time. Praying for 2 weeks time, my lord. Mr. Deepak Sinha is out station today, my lord.
Only one
He requested
defect
me
is
to
there.
take.
Annexure 3
My lord,
may be
I will
verified
remove
in
it.
petition.
I will do it. I will do it, my lord.
1 week.
My lord. My lord, next week is holidays, therefore 2 weeks may be given, my lord.
2 weeks.
2 weeks. Thank you. Oblige, my lord.
Item 6, WPT number 1906 of 2021, Ms. Amrita Sinha for the petitioner, Mr. Sachin Kumar for the respondent.
May I submit in this, Your Lordship? There is one defect with respect to the oath commissioner. That is defect number 3. Page number 190 has not been marked and it may be verified and pagination certificate of learned oath commissioner may be obtained. The oath commissioner who did the oath is no more serving as the oath commissioner, Your Lordship. So I pray that the part of the defect may kindly be ignored, and so far as pagination is concerned today, during the course of the day, I will be removing this defect, Your Lordship.
This is the same as the remaining batch matters.
Yes, Your Lordship. I am also praying that this matter may be heard along with serial number 50 and other matters, Your Lordship. I am led by my senior, Kelvin Gulati sir and Ajay sir. So I pray that this matter be heard today itself, Your Lordship. There is a IE also for stay in these matters.
Item 6. Then counsel for the petitioner, Ms. Amrita Sinha submits that surviving defect number 3 may be ignored as the concerned oath commissioner is no longer working as oath commissioner. She submits that the defect relating to pagination would be removed during course of the day. Stop. Defect relating to page number 190 is ignored. Pagination may be done by 13th April 2022. Stop. As prayed for, let the matter be tagged along with WPT (1953) of 2021 and analogous cases which are also on board today. We'll take it up when the batch matters are taken.
Much obliged, Your Lordship.
state, your lordship.
Yes. A for AG2 AC, Mr. Gaurav Raj.
Obliged, your lordship.
Item 3.
Item 3, Ashoka case, first appeal number 18 of 2021, Mr. Samitra Barui for the appellant, Mr. Najit Sinha as amicus.
Lordship, in this regard, for first appeal 18 of 2021, we had submitted a written notes.
Yes.
That is written note part 4.
Yes.
So, my senior would be joining in. If I could get a passover for few cases, my senior would be joining for further arguments.
Very well. We will have some deliberation on it today in view of the latest written notes, part 4 that you have supplied.
Yes,
But
Lordship.
first we'll try to finish off rest of the matters.
Obliged. Okay, Lordship.
Yes.
Item 7 for first appeal number 280 of 2019. Mr. Anurag Kashyap for the appellant. Mr. Ritesh Kumar for the respondent.
Yes, who appears? You are eight people.
Petitioner in the trial court is not pressing that petition.
Yes,
The
yes.
report says such.
Who is for the wife, respondent? In item 7,
Your Lordship, in item number 7, I am for the appellant, Your Lordship. Mr. Ritesh Kumar is appearing for the respondent wife, Your Lordship.
yes, so where is he? Mr. Ritesh Kumar? लिखिए ब्रदर इसको लीगल एड वहां पर प्रोवाइड कर देते हैं गुमला में.
हाँ, वो that will be better
हाँ, क्योंकि
because
वहां
the petition is pending since 2019.
हाँ, status report has been furnished by the learned Principal Judge Family Court Gumla through dated 15th March 2022 through letter of the event date bearing number 82. Stop. Perusal thereof shows that the respondent wife herein slash petitioner has not been able to pursue the execution case after November 2019, though huge outstanding maintenance amount, huge amount of maintenance awarded by arrears of maintenance awarded by the learned family court is due. Stop. It appears to the court that because of proper legal assistance and maybe due to intervening COVID situation, the wife has not been able to pursue the execution case properly. We deem it proper to direct the Principal Judge Family Court Gumla to provide her legal aid through this DLSA Gumla. Stop. Let the petitioner wife therein be approached through proper mode by the DLSA, through the DLSA Gumla, and if she otherwise is not interested in getting legal aid, the same may not be extended. And in case her request for legal aid be processed in accordance with law. so that the execution case may be properly prosecuted. Stolen Family Court would submit a report to that effect within 3 weeks. Stop. List the case on 4th of May 2022. Mr. Ritesh Kumar,
Yes, your lordship.
आपकी क्लाइंट वहां पर एक्सक्यूशन केस को परस्यू नहीं कर रही हैं, तो हो सकता है वहां उनको लीगल एड की जरूरत हो।
लॉर्डशिप हम सप्लीमेंट्री फाइल किए हैं, उसमें एक्सक्यूशन केस जो हम फाइल किए थे 19/6 को,
जहां लिखा है बाय द रेस्पोंडेंट। स्टॉप। In respect of the status of the execution case, stop. It appears on perusal thereof and on hearing learned counsel for the respondent that perhaps the learned family court has not instituted, the family court has not instituted a miscellaneous case for execution of the maintenance decree in her favor on an assumption that the same would be taken up along with the original records. Stop. Learned Family Court shall also undertake due diligence in this matter as per the consistent prevailing practice in the family courts in the state. Let a status report to that effect be submitted within 3 weeks. Matter will be listed on so and so.
Oblige, your lordship.
You tell your client to pay, Mr. Suraj Kishore.
Your lordship, I have taken instruction that he is not willing to pay because he has preferred the appeal being aggrieved of the part of the amount which has been ordered by the principal.
If you say that, then we will direct the family court to issue distress warrant, and if he fails to pay, then he will be.
Lordship, once again I will interact with him and I will
tell him this is not the way.
yes, your lord. I will pursue the matter. Your lordship, oblige.
For admission,
Yes.
for admission, item 8, WPT number 2404 of 2020, Mr. Sumit Garodia, for the petitioner. Mr. Rajiv Gandhi.
May I
Yes.
please election? This
Yes, so on behalf of the respondent, state election was praying for 1 week time in this case election. We have received the written notes of argument today morning at 9 a.m. So 1 week accommodation I am speaking in this case election.
Ms. Amrita, you have already argued this matter last March 2021, though before another bench. I was
Yes, Your
a
Lordship.
member.
But Your Lordship, the argument which was advanced then and the argument which is being advanced today and the written notes, I have already submitted the corrected written notes, Your Lordship, in this matter. Certain new points I have been raising and it will be argued in a new aspect, Your Lordship, altogether. So I'm just praying that my written notes which I have submitted today may kindly be taken into consideration.
No, we will take it up because we will be rehearing the matter. The bench is a new bench
Yes.
now.
Yes,
The
Your
only
Lordship.
question or the main question is whether advance tax through TDS is to be treated as an input and you can claim transitional credit.
Your Lordship, I won't be pressing that it will be treated as input tax credit, but I will be pressing that 140, section 140 has a wider scope and it says that credit of the value added tax and entry tax. And in that aspect, the TDS amount also comes within the purview of section 140. One of the
So even if
JGST
you
Act.
don't treat it as an ITC, still the value added tax, the advance tax being a part of the value added tax, it can be transited to the new regime.
Yes, Your Lordship, that is my argument will be. My first and the foremost argument will be that. There are other arguments also, Your Lordship, that I will be highlighting, but this will be my first and the foremost argument.
So why did you not inform us, Mr.
Today in the morning, I was
Last?
sent.
We have gone through the file yesterday, and in fact, it took some time to recapitulate the entire issue.
My apologies, Your Lordship. Even We have received the written notice of argument today in morning, Your Lordship, at 9 a.m.
Due to electricity, non-availability of electricity, I could not send yesterday, Your Lordship. But today in the morning, with all the judgments are same, which was earlier submitted before this bench and also handed over to the opposite party. However, certain amendments are there in the written submission.
Let it go then to 4th of May.
Obliged.
Revised written notes has been submitted by Learned Counsel for the petitioner. You sent it yesterday?
Today, Lordship.
I said it today morning, Your Lordship.
Achha, today morning itself. Therefore, Learned Counsel for the state seeks time. Stop. As prayed for by Learned Counsel for the respondent, let the matter appear on 4th of May 2022.
Item 9, first appeal number 12 of 2021. Mr. Salandraji for the appeal. Mr. Sumit Prasad for the respondent.
I am appearing on behalf of the appellant husband, my lord.
Non-starter. Mediation has remained a non-starter as per the report of learned mediator Jhalsa bearing letter number 901 dated 23rd March 2022. Admit call for lower court records in connection with so-and-so from the court of so-and-so. Place the matter under hearing for hearing after receipt of the LCR. As per exchange. Mr. Salandraji for the appellant.
I am appearing for the opposite party.
Sumit Prasad for the respondent.
I am hearing it because
क्या बोल रहे हैं?
maybe final hearing.
एडमिट एलसीआर हो गया, अब आएगा तो हियरिंग में चढ़ेगा.
मेडिएशन में अपीयर ही नहीं की.
हाँ, तो क्या करिए? Yes, item 10 onwards.
Item 10, number 432 of 2021, along with item number 11 to 45. Mr. Sumit Garudu.
My lord, in item 10, I am appearing, my lord. Mr. Viren Podar is arguing in physical court, my lord. Therefore, others may argue, my lord. Mr. Podar will argue on any other date.
Swaha, what is your position?
From serial number 11 to 45 and 56, my lord, we are appearing in these cases, my lord. Although there are some matters, my lord, which are pertaining to service tax also, my lord. So we have given a chart, my lord, bifurcating the service tax matters. And my senior has to argue the GST matters, my lord. He is on legs in some other court, my lord. So Lordship may accommodate me for one or two cases so that in the meantime he can join, my lord.
The difficulty with us is that you have sent a latest compilation of decision through mail. Hard copy we have not received.
Today morning, my lord, we have given to the.
Today morning you have sent it.
Yes, my lord.
Brother, आपके यहाँ भी पहुँचा है क्या?
हाँ, अभी जस्ट पहुँचा है. अभी जस्ट.
Milord, those copies, Milord, those judgments may also be, Milord, forwarded to us also, Milord, the state respondent.
We have emailed the judgments, my lord, to the other side also.
No, I have not received, Mr. Shwaha. I am also appearing in two matters.
Very well, wait for some time. Let all the councils be present, then we will. Such a voluminous written notes, compilation has been sent today morning. Let us see what we can do about it.
Item
Next.
Item 46, WPT number 746 of 2021, Mr. Nitin Kumar Prasad for the petitioner. Mr. Rajiv Sinha, Mr. P.S. Pati, Mr. Pradhat Kumar Sinha for the respondent.
If it may please your lordship.
Yes.
Your lordship, in this matter, vires of section 16, subsection 4 of GST has been challenged. Input tax credit has not been granted under section 16.4, your lordship.
This is an old challenge. There are many other petitions which
Yes.
might.
They are pending before Honorable Division Bench number 1, Your Lordship. The Vaides matter.
Give the number so that we can indicate in the order. It will be easy for assignment.
Your Lordship, I'll just provide the number.
Give the number to the court master.
Yes, Your Lordship.
Since the virus of Section 16 within bracket 4 of the CGST Act 2017 is under challenge, along with the amendment to Rule 61(5) of the CGST rules, inserted by notification dated 9th October 2019, let the matter be listed before an appropriate bench as per the present distribution of roster. Stop. Then counsel for the petitioner submits that similar issues are pending before this court, such as in WPT number so and so, so and so. Stop. Office to take note of.
Item 14. Item 47. Civil 7 of 2021. Mr. Nagendra Tiwari for the petitioner.
Hello, my lord. This is for appointment of lecturer, and order has been passed by this honorable court on 20/11/18. Since then, no compliance has been made. Order was given to the university. University, in compliance of his order, this order, he has written letter to the respondent JPSC, stating legal impediment that unless the JPSC recommend the name of the petitioner, he is not able to appoint the petitioner in light of up to amended University Act. That is why, and since then,
Mr. Tiwari,
JPSC is sitting over it without giving any order.
Mr. Tiwari, ये डिवीजन बेंच से रिट पिटीशन डिसाइड हुआ, इसमें कोई रूल या सेक्शन वगैरह चैलेंज में था क्या?
जी, ये आइए पिटीशन हम लोग दिए थे, जिस पर ये ऑनरेबल कोर्ट ने ऑर्डर किया था कंसीडर के लिए।
डिवीजन बेंच में क्यों लिस्ट हुआ था मिस्टर मेहता?
क्योंकि डिवीजन बेंच से ही डिसाइड हुआ था हुजूर।
मिस्टर मेहता,
ये डिसाइड हुआ, वो हेडेड बाय मिस्टर जस्टिस,
वो सब देख लिए
पटेल।
बेंच का कॉन्स्टिट्यूशन देख लिए, सवाल दूसरा कर रहे हैं, उसकी जवाब। मिस्टर मेहता, व्हाई वाज इट डिसाइडेड बाय डिवीजन बेंच?
Actually, this case was tagged with LTA. Later on, it has been segregated, and hearing has been made by double bench.
Very well. Mr. Mehta, do you have anything to say today?
Nothing, my lord, sir.
I only want to say that this order should be complied. But this is my only prayer.
For 6 weeks' time to file show cause, lordship, for the first time it has.
My lord, sir, I also do not recollect as to why the matter was listed before the division bench, and if I have, your lordship would maybe.
So better seek instructions, both the state and the
JPSC,
JPSC and Vice Chancellor.
Yes,
you are for the JPSC, Mr. Alam.
Yes, your lordship.
Okay. Then counsel for the opposite party number 2, Vice Chancellor Ranchi University and the Chairman JPSC, both pray for and allowed 3 weeks time to seek instruction as to whether the order has been complied or not. Stop. An affidavit to that effect be filed. List it after 3 weeks.
Grateful, my lord.
हुजूर उसमें टाइम दे दिया जाए,
3 सप्ताह का टाइम दिए हैं।
टाइम एवं दे दिया जाए हुजूर की कितना दिन का उसको किया जाए,
टाइम तो दे
और
चुके हैं
फिजिकल
3
में कर
सप्ताह
दिया
का।
जाएगा।
हाँ, 3 सप्ताह का टाइम दे चुके हैं भाई, आप सुन नहीं रहे।
अच्छा ठीक है हुजूर, तो लेकिन फिजिकल में कर दिया जाए हुजूर।
फिजिकल में ही होगा, ये तो अभी एक्सेप्शनल में हम लोग इसमें कर रहे हैं। लेट इट द मैटर बी लिस्टेड व्हेन द कोर्ट इज फंक्शनिंग फिजिकल।
Item 48, WPT number 1117 of 2021, Mr. Visnudev Bhagat for the petitioner, Mr. Sachin Kumar for the respondent.
करा दिया सर।
Who is appearing, Mr. Bhagat?
Yeah, I am appearing on behalf of the petitioners. Your lordship. Your lordship, I have submitted written submission before yesterday on mail.
आप अपील में जाइए ना, ये तो प्रॉपर ऑफिसर सारा ग्राउंड ये लिए हुए हैं काउंटर एफिडेविट में।
सर कुछ मैटर करना है इसमें। एक्चुअली सर हम इंस्पेक्शन रिपोर्ट जो एनेक्सर 6 में लगा है पेज 85 पर थोड़ा सा देख लीजिए। हम पढ़ के सुनाते हैं कि हमको क्या इंस्ट्रक्शन दिया गया था और हमारे साथ क्या किया गया हुजूर।
तो वो अपील वाले भी तो सुन सकते हैं ये सारे।
नहीं सर, देख लिया जाए 85 पर क्या हुआ। हमको 73 का प्रोसीडिंग ही हमको शुरू नहीं किया गया और 73 में ऑर्डर करके और हमको DRC 7 दे दिया हुजूर। उसमें एक भी प्रोसीडिंग 142 का कोई पालन नहीं किया गया।
आपने अपने रिट पिटीशन में कहाँ लिखा है कि आपको DRC 01A DRC, ये तो कह रहे हैं कि भाई ये सेक्शन 61 से कनेक्टेड नहीं है।
रिट पिटीशन में भी लिखा है मैंने, रिट पिटीशन में मैंने
लिखा है। कहना है कि वो सेक्शन 61 से स्क्रूटनी ऑफ योर रिटर्न से रिलेटेड नहीं है, ये इंस्पेक्शन के बेसिस पे है, इंटेलिजेंस इनपुट के बेसिस पे है।
सर इंस्पेक्शन किया गया और इंस्पेक्शन में हमको बुलाया गया क्लियर करने के लिए। इंस्पेक्शन में कुछ मुद्दे उठाए लोग। हुजूर 85 पर देखा जाए कि क्या इंस्ट्रक्शन दिए पेज 85 पर।
आप ये बताइए ना कि आपको कहाँ ये लिखे हैं कि और आपको ये प्रॉपर GST 01A with GST 01 शो कॉज अंडर सेक्शन 73 ये सब नहीं दिया गया।
सर 40 पारा 40 में हम लिखे हैं पारा 40 में हम लिखे हैं 40 एंड 41, 42 यही डिटेल में हम लिखे हैं कि हमको मैंने हमारे साथ 73 का प्रोसीडिंग ही नहीं शुरू किया गया।
कहाँ, किस, वेयर इज द स्टेटमेंट?
जी
ये पेज 27 का फर्स्ट 3 लाइंस में है।
जी
So you have not answered this specifically, Mr. Dubey. ये पैरा 42 का स्पेसिफिक आंसर नहीं है आपके पास।
हुजूर 85 पर हमको इंस्पेक्शन रिपोर्ट में इंस्ट्रक्शन दिया गया।
वो हम समझ गए हैं, वो हम लोग वी हैव सीन योर इंस्पेक्शन।
जी
आपका कहना है कि जो इंस्पेक्शन करने वाले हैं वो जुरिस्डिक्शनल ऑफिसर नहीं है, प्रॉपर ऑफिसर नहीं है सेक्शन 73 का इशू करने के लिए। उन्होंने ही डायरेक्ट सेक्शन 73, सेक्शन 50 ये सब का आपको जवाब देने
नहीं किया गया। उसमें लिखा गया कि आप अपीयर हुए अन्यथा की स्थिति में, अपीयर हुए नहीं तो किया जाएगा। हम अपीयर हुए हैं हुजूर, ऑर्डर शीट में क्लियर है कि अपीयर हुए हैं, लेकिन एजुकेटिंग ऑफिसर अफसर ने ऑर्डर शीट यू हैव 53 पर, पेज 53 पर हमको 85 पर निर्देश दिया गया कि उपस्थित होकर के खरीद बीजक और भुगतान साक्ष्य दीजिए, अन्यथा की स्थिति में आप पर 73, 50 और 125 की कार्रवाई की जाएगी। और पेज 53 पर ऑर्डर शीट में जो पदाधिकारी एडजुडिकेट करते हैं उन्होंने लिखते हैं निरीक्षण के दौरान व्यवसायी द्वारा खरीद बिक्री एवं भुगतान साक्ष्यों का सत्यापन नहीं कराया गया। निरीक्षण के समय पाए गए अनियमितताओं के लिए व्यवसायी को दिनांक 17/1/20 को अधीक्षक कार्यालय में उपस्थित होकर अपना पक्ष प्रस्तुत करने हेतु अधिनियम की धारा 73, 50 और 125 के अंतर्गत निर्देश दिया गया। यहाँ पर 85 में जो हमको निर्देश दिया गया उसमें कोई सेक्शन नहीं कोट किया गया, और हम कह रहे हैं कि ये जो इस तरह से मांगा जाता है एविडेंस, उसके लिए 70 में प्रोविजन है कि कोई भी इंस्पेक्टिंग ऑफिसर को अगर कोई एविडेंस चाहिए तो 70 में ही प्रॉपर ऑफिसर है कि मांग सकते हैं। तो हमको यहाँ कोई 73 का नहीं दिया गया। और यहाँ
My lord, may I submit one thing, your lordship? I have stated in paragraph 62 of my counter affidavit. May I have a look, your lordship? Page number 29 of my counter affidavit. We have stated regarding paragraph 45 of the writ petition, lordship. Page 29 of counter affidavit, paragraph 62.
कहाँ इसमें? Where have you answered that you issued the intimation under DRC 01A and then DRC 01 and then initiated a proceeding show cause under section 73(1) और इंटेलिजेंस इनपुट से आया था, तो फिर ये 74(1) का होगा कि 73(1) का होगा?
वो तो जो 74(1) का होगा।
आपने तो 73 में प्रोसीडिंग किया है, ऑर्डर किया।
उसका मैं स्पेसिफिक रिप्लाई हम देते हैं। उसका एक
रिप्लाई क्या दीजिएगा? नहीं किए होंगे तो आपका वो प्रोसीजरल एरर से सफर करेगा। अब जजमेंट्स एनकेएस का भी आ गया है, पहले भी महादेव कंस्ट्रक्शन का जजमेंट है।
Any specific allegation not replied in para 62.
My lord, but so far the section 53 sub clause 5 read, your lordship, read with section 51, your lordship.
नहीं, आप take instruction, we will grant you one more indulgence. If it has not been done, then you may have serious difficulty in defending the proceeding.
My lord.
If the procedure had been followed, then we would have relegated him to the appellate authority.
Yes.
If there is a violation of principles of natural justice procedure, then we will maintain it.
My lord.
Learned counsel for the petitioner submits that no such pre-show cause refers to the statements made in the writ petition, specifically paragraphs
42.
नहीं ठीक है, specifically paragraphs 41, 42, 43, and submits that the procedure prescribed for initiation of proceedings under section 73(1) has not been followed. Petitioner has been prejudiced because of violation of principles of natural justice. He has taken other grounds as well relating to the jurisdiction of the inspecting officer to call for to initiate a proceeding under section 73(1) of the Act straight away without calling for documents in terms of the relevant provisions of the JGST Act. A counter affidavit has been filed, though the specific contention of the petition doesn't stand answered in so many paragraphs. Learned counsel for the state, Mr. Deepak Kumar Dubey, AC to AG2, seeks one more indulgence to clarify their stand. 3 weeks' time as prayed for is allowed by way of last indulgence. 1 week thereafter to the petitioner to file reply to the supplementary counter affidavit if so necessary. List it after 4 weeks.
Item 49, WPT number 1458 of 2021. Nitin Kumar Pasari for the petitioner. Mr. Kumar Yadav for the
If it may please, Your Lordship. Your Lordship,
Yes.
I was praying for an adjournment in this matter to file counter rejoinder, Your Lordship.
Why are you taking so much of time to file rejoinder?
Your Lordship, we could not obtain instructions. 1 week time may be granted, Your Lordship, will file the rejoinder.
Counsel for the petitioner, Ms. Siti Jalan, prays for is allowed 1 week more time to file rejoinder to the counter affidavit. By way of last indulgence, since earlier time has been granted for that purpose. On 8th February 2022.
Much obliged, Your Lordship.
Thereafter.
I appear for the state.
Mr. Salona Mittal for the state.
Item 15, WPT number 1892 of 2021. Ms. Amrita Sinha for the petitioner. Mr. Ashok for the petitioner.
Wait, please.
May
Alert your
please, Your Lordship. In this matter,
Yes, Ms. Amrita.
yes, Your Lordship. In this matter, I am led by my senior, Your Lordship.
Yes, yes.
Lord, may I have your lordship? Yes, Lord. Lord, these are items, Lord, 50 to 55. The lead matter, my lord, is the first assessment here, which is item 54, where the compilations have also been filed, my lord.
54.
Compilation.
1953. What is the status of those petitions which have come back from after the Supreme Court's?
Lord, they are pending before my lords. In fact, it was heard by the previous bench, but then His Lordship Justice Patel, my lords, became the chief of the Delhi High Court and therefore could not be heard after that. It was fully heard, my lords, on 3 occasions, but could not be. But, my lords, in this case, I have a very short submission to make, but it is coming to your lordship. Because the lordship has seen, my lords, that Delhi there is.
Perhaps your voice is a bit feeble.
I see. Well, I'll just give me a second. Now, Lord, is this better now? The voice is better now?
Slightly better. If there is no disturbance, then it is good, but otherwise, the moment somebody speaks, it is.
Well, Lord, I would have actually hoped to be there physically, but since your lordships were today not sitting physically, so therefore, my lords, we've had to.
No, we understand.
My lord, in this case, my lords, I don't wish to, my lords, trouble your lordships with the merits of the matter as such. I'll tell your lordships why. This is, my lords, a challenge essentially to an order of assessment in all these years. And the challenge, really speaking, is not to the decision on merits, but to the decision-making process. And, my lord, ultimately, my lord, therefore, I am going to be praying to my lord that if your lordships find that we have made out prima facie case.
Not fully audible, Mr. Gulati, sorry. My loudspeaker is at 100, so it can't be more than that.
My lord, is it better now? I've brought the speaker next to me now. Is it?
It is otherwise audible, but sometimes the vital submissions get missed out. Yes, you said that you don't want to bother us with the merits of the.
Only, my lords, what is the subject matter of challenge really is the decision-making process. And the why we say that, my lords, is that there were certain preliminary objections which we raised, which go to the very root of the matter. And unfortunately, my lords, in this case, I'll just show your lordships a few facts. What has happened is that they have actually backdated that order of preliminary objections. And the reason for doing that is, my lords, so that they could create a demand. They could create a demand because my lords, at that point of time, it was the year-ending proceedings. And they were really under an impression that they could collect this tax almost immediately. And therefore, my lords, if I am right in what I am submitting, my lords, then I would commend the court to consider remanding the matter to the assessing officer himself to reconsider the matter afresh in the light of what we have said as the preliminary objections. Normally, my lords, the view is that you can take all these issues in an appeal also. And what is so special about sending the matter back?
For that, my lords, I would, my lords, request my lords to consider the decision of the Supreme Court in the case of L.K. Ratna, where, my lord, your lordship recalls, I have put it as a part of my compilation one paragraph only I want to show your lordships, where, my lords, the principle really is this, that if the statute provides for a trial and an appeal, it is not therefore sufficient to say that even though you may have had an unfair trial, it can be corrected in an appeal, because and the Supreme Court really says when the statute mandates a trial and an appeal, the appeal as well as the trial should be fair. And if procedural fairness is missed out, then, my lords, I lose an important leg in my proceedings. And why I say that, my lords, is I will show your lordships from the facts that on admitted facts, this is a case where the proceedings are completely without jurisdiction, in the sense that there is no limitation. The period of this is beyond period of limitation. That's number one. That's the first preliminary objection which we raised. The second thing which we said was that they have, my lords, invoked the provisions of section 11(5) of the Entry Tax Act to proceed against me in this case. The foundational show cause notice is under 11(5). Now, 11(5) says, my lords, that proceedings will be initiated if, my lords, we have willfully sought to evade tax. It is on that foundation, my lords, that a proceeding starts. There is not even a sentence in the show cause notice which seems to suggest that the proceedings or the tax, my lords, was withheld willfully, which is an essential requirement of the section itself. And, my lord, Supreme Court says that when a statute uses the words like intent to evade, etc., the allegation should be there in the show cause notice before you can proceed against a person concerned. And in this case, my lords, the issue really is, they say we are proceeding against you because you have not obtained a registration under the Entry Tax Act. And our case is that there was no requirement for a registration because we did not fall within the ken of the entry tax provisions at that point of time. It is these two basic, my lords, objections which we had raised. And number three, my lords, the third preliminary objection was that they have sought to raise tax on HSD which I use in my manufacture. Now, under the entry tax provisions itself, my lords, under the heading consumption and use, in the definition of consumption and use, they have specifically excluded those items which are used in the manufacture of other goods. It is my case, my lords, that when I am manufacturing steel and iron and steel, HSD forms an essential ingredient in the manufacture. And in fact, my lords, the division bench of this court in the case of Brahmaputra Chemicals has dealt with this aspect in great detail. And they have said that it is to be treated as a part of the input. So those were the three preliminary objections which I had raised before the assessing officer. He, my lords, heard us on two occasions, and then, my lords, on a particular date, which is 24th of November, he asked us for certain information and we supplied that information. And after that, my lords, straight away we received an assessment order on 112. Once we received an assessment order, my lord, we applied for a certified copy of the proceedings. And in the certified copy, for the first time, it has emerged that he has passed a detailed order purporting to decide my preliminary objections on 24/11 itself. So, my lord, and what is intriguing, therefore, I've annexed the entire photocopy of the certified copy of the order sheet, from which your lordships will see there is a countersign by the SSC's representative on each hearing, except for this particular hearing. And, my lords, when we say this in our writ petition, in counter what they say is that there is no obligation on me to communicate. You have to apply, they say, for an order. But what they forget to tell your lordships is that yes, it is my obligation to apply, but only if I am aware of it. And, my lords, why I am emphasizing on this today is, it's not about, my lords, this 20, if I file an appeal, I have to deposit 20% tax. So it's not a question, my lords, for this SSC at least, of not being able to deposit. In fact, I am going to suggest to your lordships that if your lordships want to test our bona fides, I am ready to deposit this 20% in your lordship's court, my lords, which can be kept in an interest-bearing security, because it's not about money here. It's about, my lords, the process. Because if I succeed on these preliminary grounds, my lords, nothing more requires to be done. And with this, my lords, background, now, if your lordships permit, I'll give your lordships 4 or 5 essential facts which may be necessary for a decision in this case. May I place it, my lords, for your lordships?
In that case,
yes,
since if we remand it to the assessing authority afresh,
yes,
there should be a demonstrable finding or a demonstrable ground on which we have to render a finding that the procedure was not fair and the order was antedated.
That is number one. That is number one, my lords. Number two, if your lordships agree with me that the issues which we are classifying as preliminary issues are issues which go to the root of the matter, then, my lords, that of course should be decided as and that should be decided as a preliminary issue. Why? Because, my lord, an appeal lies only against an order of assessment and reassessment. I will show you, lordship, from section 20. It specifically says appeal from an order of assessment and reassessment. There is no appeal provided when an order is passed in the nature of deciding a preliminary objection. There, my lords, the remedy will be a revision under section 21, which does not require a pre-deposit. And that is why this problem occurred. We were conscious of this position, therefore we told him, you please decide this issue as a preliminary issue. Had he decided it and given me a copy, I would have immediately challenged it in a revision and then come to your lordships after that. If the revision went against me. But by this stratagem, what they have done is they have actually passed an order of assessment and almost simultaneously decided that issue of the preliminary issue. As a result of which, my lords, that order actually will stand merged into the order of assessment, because now there is a standing demand. So we are really speaking stuck, my lords, between a rock and a hard place in that sense. So that's why, my lords, I was saying
what is the date of the order deciding the preliminary objection, and what is the date of the assessment?
Yes. Now, my lords, the date on which they purport to decide this preliminary objection is 24/11/2020.
Yes.
And, my lords, the date of the order of assessment is 1/12/2020. And thereafter, my lords, something interesting happens. In this order of assessment, just as a side issue, my lords, I'll tell your lordships. In the order of assessment, what they do is,
the order deciding preliminary objection is dated 24th December.
24th November 2020.
Yes.
My lord, this your lordships will find at pages 227 to 231.
Yes.
And the order of assessment, my lords, is dated 1st of December 2020. And that is, my lord, next year 13 at 208 to 213. My lord, I had challenged this order earlier before, my lords, in writ petition tax number 1289 of 2021.
Yes.
Now, what happened was, once we challenged this order, and my lord, one of the things which we pointed out in that challenge before, my lords, was that this assessment order is an order which is totally flawed because of non-application of mind. Why? Because, my lords, the assessing officer picked up the entire turnover relating to high-speed diesel oil and treated it as tax. Because, my lord, normally, if supposing the turnover is 1,000 rupees and the tax rate is 15%, you will put as tax 15% of that 1,000. What the assessing officer in this case did was, he picked up the entire turnover and treated it as tax, and then loaded onto that a penalty of the same amount, and then, my lord, interest at the rate of 5% per month on that amount. So when we pointed this out in writ petition before, my lords, he suo moto, my lords, revises his order on 24/3/2021. 24/3/2021, which is annexure 18 at page 237. And, my lords, then what happens is that once this order is passed, he reduces now this demand from 137 crores. It comes down, my lords, to 11 crores and then he imposes a penalty of 11 crores, and then on HSD a tax of 4. So total demand now becomes about 52 odd crores. From 137, it straight drops to 52 crores, out of which also, my lords, 16 crores is the tax, 16 crores is the penalty, and my lord, the balance is all 5% interest per month. So, my lords, we come back to your lordships and point this out, and we seek a liberty from my lords to withdraw this writ petition in view of the new order which has been passed, with a liberty to file fresh proceedings, whatever may be available to us in law. And then, my lord, we filed this fresh petition on 17/5/2021, which my lords is currently hearing. Now, my lords, I only want to show your lordships 2 or 3 background facts, my lord, may be necessary, just to give your lordships a conspectus here. My lords, the entry tax provision initially, my lords, was the 1993 Act from Bihar, which was adopted in Jharkhand. Thereafter, my lords, on 16/7/2011, the Jharkhand state brought about its own Act of 2011, which is the current, my lords, Entry Tax Act, which I have annexed as Annexure 1 to my writ petition. So this Act, my lords, was challenged like it was challenged in all other states. The entry tax legislations were challenged on the ground that these legislations are not compensatory in nature, because the concept of compensatory tax was then, my lords, prevalent in view of those decisions of Atyabari Manomobi. And this court, my lords, by an order of 3rd of April 2012, held the Act to be ultra vires. Then, my lords, comes that celebrated decision in the case of Jindal, 9 judges, which is, my lords, dated 11/11/2016, where they said there is no concept of a compensatory tax. You have to justify the tax on the ground that it is violative of Article 14, 19 or 304A. And, my lords, in that decision, my lords, the matters were limited to the regular benches of the Supreme Court to decide in accordance with law. Now, my lord, one important date, my lord, may note just before is the date which your lordship have noted, which is 22/3/2017. Insofar as Jharkhand is concerned, my lord, the state of Jharkhand had filed an appeal against the order of the High Court in the Supreme Court. Now, that civil appeal number, my lord, is 8275 of 2012, which got decided by the division bench on 22/3/2017. The significance of this date, my lords, is this, that the period of limitation which is available to the department to proceed against me in the pending matters, my lords, would actually start from this date at the highest, because we are concerned, for example, in the matter I am appearing, my lords, this is the assessment year 11/12. Now, my lords, the section requires the assessing officer to complete the assessment within a period of 2 years. So, therefore, I am arguing against myself at the moment. I am saying at the highest, they would get limitation from 22/3/2017, because that is the date the state of Jharkhand's appeal was allowed, and, my lords, the matters were remitted to the High Court to consider essentially 3 issues, if and when they arose. The first was, my lords, whether the whole state can be treated as a local area or not. That was one issue which was flagged. Number 2, my lords, if a person is making imports from outside the country into the country, can that be a subject matter of entry tax? That is issue number 2. And the third, my lords, issue was whether if a state is offering incentives to its local industry and not offering it to people from outside, would it violate Article 304A? Well, that order I have annexed. This is Annexure 3 at page 124 to 145 of the Supreme Court. It flags these 3 issues and says the High Courts can decide this issue once the SSCs file those writ petitions. And any other issue, of course. Now, my lords, one more date your lordships may note. This is, my lords, 9/10/2017. Another decision, my lords, of the Supreme Court came in the case of State of Kerala versus Father William Fernandez. This is, my lords, a decision of the Supreme Court which only deals with one question. And that question was whether if an import is made from outside the country, can it be amenable to entry tax? And this question, my lord, was decided with reference to statutes of 3 states, which included, my lord, the state of Jharkhand, but with reference to the old Entry Tax Act, which is the Bihar Act of 1993. Because, my lords, in the new Act of 2011, imports from outside the country are actually exempt under the new Act. But why this becomes significant is because the department is now trying to latch on to this date of 9/10/2017 as the date on which they say their limitation starts. And totally forgetting, my lord, that the first matter which was decided for the 2011 Act, that is the date of 22/3/2017 and not 9/10. So that's the significance of this date, 9/10/2017. But I have annexed all these decisions in my compilation. If need be, I'll place them. Now, my lords, what happens thereafter is I file my writ petition. That's the first question which your lordships put to me, which is writ petition number 3884 of 2017, which I file in the year 2017, which is pending before my lords, where the provisions of the Entry Tax Act are challenged on 3 grounds. One, my lord, in my case is a peculiar case because we are based out of Jamshedpur. And one of the cases which we are raising is, one of the issues which we are raising is that Jamshedpur does not come within the expression local area because it had its own scheme historically, and the act as it stands does not cover Jamshedpur. But that is an issue which your lordship to decide in the other petition. And the other, of course, is Article 304A. Now, my lord, the first show cause notice, and this is admitted, which has been issued for the present proceeding, is of 10/5/2019. That's a date, my lord, which your lordship may want to...
10/5?
10/5/2019. This is, my lords, Annexure 5, page 180 and 181.
This is the show cause notice.
It is the show cause notice, my lords. And this is the first show cause notice which has been issued to me. And, my lords, your lordships may also just kindly make a note. I have made an allegation in paragraph 14 of my writ petition that this is the first show cause notice which has been issued to me, and the response is in para 11 of the counter affidavit, and this fact therefore is admitted by them that yes, this was the first show cause notice. Now, my lord, kindly just see with me this is page 180. This is the show cause notice.
Page 180.
Page 180, my lords.
Yes.
My lords, there is an original copy and a typed copy. May I request my lords to kindly have the original copy for a minute, which is at page 180 itself, the first document. My lords will see that there is a cyclo-styled notice which has come. Fourth recital, if your lordship will see, on the left hand column, your lordship will see a double tick. My lords have that at page 180. My lords, fourth recital, sentence beginning, whereas you have failed. There is a double tick on the left.
Yes.
So therefore, so this is by the assessing officer himself. He is invoking this. Now it says, whereas you have failed to apply for registration, though you are liable to get yourself registered under the Act, therefore you are hereby directed to show cause by 10(6) as to why assessment penalty not be imposed under section 11(5) read with rule 14 of the rules. My lord may kindly mark this because I'll immediately take a lordship to section 11(5). So it is their case that I have not obtained registration, therefore I have violated section 11(5) read with rule 14. Now, my lord, your lordship will, while your lordships are at that page, your lordship will see that there is no allegation saying that I have willfully failed to obtain registration or willfully failed to pay tax. There is nothing in this show cause notice. Now, with this, my lord, if your lordship just kindly have section 11(5), which is at page 69. I'll just place this entire second hinges on this. May I place it?
Yes.
If upon information or otherwise the prescribed authority is satisfied that reasonable grounds exist to believe that any SSE or any person other than a registered SSE has been liable to pay tax in respect of any period and has nevertheless willfully failed to apply for registration. On the registration, the prescribed authority shall, after giving the SSE or such person a reasonable opportunity of hearing, assess to the best of his judgment the amount of tax, if any, due from the SSE or any other person in respect of the period and all subsequent periods. The prescribed authority shall direct the SSE or other person to pay by way of a penalty in addition to tax to assess a sum not exceeding 50 rupees for every day of the period due from the SSE or any other person has failed to apply for registration, or an amount equal to the amount of tax assessed, whichever is higher. Kindly also see the proviso because that deals with limitation.
Yes.
Provided that no proceedings for such assessment shall be initiated except before the expiry of 2 years from the expiry of the period to which it relates. Provided further that a proceeding initiated under this subsection shall be concluded within a period of 2 years from the date of initiation. So, two things which your Lordship will kindly see. First of all, Section 11.5 mandates that the prescribed authority must have reasonable grounds to believe. Now, just pausing here for a moment, your Lordship finds a similar expression in Section 147, 148 of the Income Tax Act, reason to believe, where they say though you have to record those reasons to believe. In that famous case of Kelvinator, Malord, and calculated discount, the old Constitution bench, they said reason to. So this is a jurisdictional section in that sense. It is not to be resorted as a matter of course. The jurisdiction is founded on his reasonable grounds to believe that somebody has evaded the provisions of the Act. Then the next important expression is that the reasonable ground to believe should be that I have willfully failed to apply for registration. And my lord, number 3, what is important is that the proviso provides that proceedings should be initiated within a period of 2 years from the end of the assessment year for which the proceedings relate, and you must be able to conclude the proceedings with a further period of 2 years. Now, it is on this, my lords, that I filed 2 replies before the assessing authority. One saying that in my case, the period of limitation is clearly gone, and therefore limitation is an issue which goes to the root of the matter. Number 2, we pointed out, my lord, that you have not made an allegation of willful evasion. So, therefore, the foundational basis of your notice is flawed. You cannot proceed under 11. Now, my lords, during the course of proceedings, as your lordship will now see from the order sheet, he hears me on various dates. And my lords, fixes the next date. We again are asked for certain information. We give that information. Leading up, and on each date, my lords. Now, may I at this stage just show your lordship the order sheet? So, as I was pointing out, my lords, each date they take a counter signature from my authorized person who is attending the proceeding. And I have also filed, my lord, an affidavit of that person who had appeared before the authority to bring to your lordship's notice that this is their practice, this is what they do, and this is what they did in this case. So, in all your order sheets, your lordship will find my counter signature is available. It's only on this 2411 that it is not there. And my lord, my allegation in this regard is contained in paragraphs 24 to 37 of my writ petition. And in 3 paragraphs, they say, I have no obligation to inform you. You were there. I have informed you, but there is no obligation to send an order to you. Now, my lord, therefore, we have a situation where the assessing officer in the counter affidavit says, I have informed the SSE in the sense that the SSE was sitting in my front of me when I was passing this order. Versus, my lords, the SSE's affidavit who says that none of this happened. Now, in a situation like this, what course will a court follow? Is one man's word against another? Now, my therefore respectful submission to the court is, in such a case, your lordships will go by the normal flow of events. And what is the normal flow of events? You are obtaining a counter signature on each hearing. You have somehow not taken it on this hearing. So when we have to balance, my lords, who is right on a preponderance of probabilities, in my respectful submission, my lords, the court would go by what the assessing officer has normally been following in every case. And therefore, my lords, I say that had I been given an opportunity to challenge this particular order, I would have gone in a revision without paying anything. And it is not that money that I am running away from, because as Tata, I cannot plead that we have financial stringency. So therefore, I am saying to establish my bona fides that it is not running away from this amount, that I am ready to deposit this amount before my lords. Because what happens is, my lords, if I deposit this amount before them, and if I am ultimately right in my submission that they have no jurisdiction to go against me for these years, then, my lord, this money is never coming back to me. So I am saying I will deposit it in court before my lord. Your lordships can put it in an interest-bearing security, and in the meantime, direct the assessing officer to hear me again and pass a reasoned order. And if necessary, then, my lords, if it goes against me, which in all probability it will, then at least I have a chance to go in a revision. Because at this moment, there is a demand sitting on my head because of the assessment order. This order of 2411 actually has merged into the order of assessment. And what is, my lords, also significant is this. One more factor which shows to your lordships that this order was actually not passed on 2411. In the order of assessment of 112, which is a subsequent event, there is not a whisper of this order. Not a word about this order. And what is significant is this. My lord, on the previous date prior to 2411, the assessing officer asked us for a certain detail as to how I am using HSD in my ultimate production. He asked me to give a flow chart. I gave a flow chart on 2411, which is finding itself in the assessing officer's order. But this order, there is absolutely no reference. And the answer the assessing officer gives in his counter is, why should I refer to it? I have already decided that issue. There is no occasion for me to refer to it. So,
what are the different periods covered in different writ petitions?
Yes, my lord. So, in fact, my lord, if your lordship just kindly has page 233, 11/12 to June 17, my lord, because after that the GST had come in. 233. Let's see. And I want to, my lords, show your lordship this chart, because this itself will give your lordships an impression of why I am laboring this point today. Kindly just have page 233 in my petition.
Page 233 of the writ petition.
Of the writ petition, my lords, annexure 15.
Yes.
Now, my lord, just kindly see the chart. Kindly see the first period, 11/12. This is the matter which I am appearing in before my lords.
Yes.
Now, kindly see, I have broken this up, my lords. HSD oil and other than HSD oil. Now, my lords have that.
Yes.
So, other than HSD oil, my lord, your lordship sees, is a figure of 11 crores 88 lakhs. Right, my lord?
Yes, yes.
And HSD oil is 4 crores 67 lakhs. Right? Now, kindly see the next column. Interest is 19 crores 86 lakhs. How? Because they have charged 5% per month under that Rule 14, which incidentally also requires willful failure. That's the expression there. Penalty is how much, my lord? 16 crores 55 lakhs. And the total demand is 52 crores. Now, the next column, your lordship will see, initially, as I told your lordships, it was 137 crores was the demand. 84 crores, they are now themselves knocked out after we filed that writ petition, saying that this is totally non-application of mine because they have picked up the entire turnover and treated it as tax. So they themselves correct it and bring it down to 52 crores. So out of that, tax, my lord, is only about 16 crores. So if I had to file an appeal before the appellate authority, I would be required to pay 20% of 16 crores because that's the mandate of the Act. So, my lord, out of this, for all these 6 years, therefore, the demand is 84 crores and odd. So, I would have to deposit 17 crores by way of pre-deposit for all these years. So, I'm giving you lordship ballpark figures, but your lordship sees 44 crores and 40 crores. The total will be about 84 crores and 6 lakhs. And I will be made to pay 20% of this amount if I were to file an appeal.
The final cumulative figure is 84 crores, 80 lakhs and all.
Yes, but 8480 is knocked off. That's a wrong figure. Well, 8480 is knocked out now. They have themselves deleted that.
Achha, deleted.
I am giving your lordships, my lords. I am giving your lordships, my lords, the figure lordship will see from 1112 right till 1718 now. The cumulative of all these 6 or 7 writ petitions. Now the lordship will see for HSD the figure is 44 crores. Right at the bottom, my lord.
Yes.
For all these 6 years.
Yes.
44 crores, and the next is other than HSD, that is items other than HSD, it is 40 crores and 67 lakhs.
Yes.
So therefore I said, my lords, the total will be about 84 crores and 67 lakhs as tax due. If we go by the assessment order for all the years, all the 6 years which your lordships are considering, the total will be 84 crores and 67 lakhs as tax. Interest and penalty is separate, my lords. This 84 is different from that 84 which your lordship sees at the top. I hope, my lords, I have made myself clear. May I just place it again for your lordship?
Yes.
I'm sorry. Okay. So, my lords, kindly just see the first column then, 2011-12. Now, just extreme right, your lordship finds the figure of 84 crores.
Yes.
Just next to that, my lords will kindly see 137 crores.
Yes.
Lordships have that. Now, there is an asterisk there. Kindly go to the bottom of the page.
Yes.
May I just read this? Kindly note that while determining the assessed tax on HSD oil for financial year 11-12, the tax authority has taken the assessable value excluding CST, that is 31 crores and 17 lakhs as assessed instead of calculating tax on this value at a rate of 15%. Thus, the amount of tax assessed, interest and penalty has been over-assessed to the tune of 84 crores.
Yes.
So, this is what he did. And when we filed a writ petition, we pointed this out. So, he himself then revised his order, suo moto, and now the final figure, my lord, is in the column next to this 137 crores, which is 52 crores and 98 lakhs. My lords have that. In the third, from the right hand side, my lords, third column.
52
right at the
crores.
top. 52 crores, 98 lakhs. Right, my lords? Now, the breakup of this 52 crores, 98 lakhs is the first 3 columns. It is, my lord, tax, interest and penalty. My lord, interest is 19 crores and 86 lakhs. Penalty is 16 crores and 55 lakhs. And the tax amount, my lords, is also the same, which is 16 crores 55 lakhs, which is, my lords, 11 crores 88 lakhs plus 4 crores 67 lakhs. Because, my lords, the penalty is 100% of the tax amount. So this 52 crores, the breakup is 16 crores 55 lakhs for tax, 16 crores 55 lakhs for penalty, and 19 crores 86 lakhs for interest. That is a total of 52 crores. My lords have that.
No, this is the last part which you are explaining, perhaps.
I see. I'll probably, my lord, there is a problem in my mic again. So, my lord, your lordship now first makes a note of this total figure which they are demanding, which is 52 lakhs 98,000.
Yes.
52 crores 98 lakhs. Right, my lord? This is the total they are demanding.
Yes.
Now, the breakup of this 52 crores 98 lakhs is, the lordship sees the next column just on the left hand side, penalty. My lord, have that?
Yes.
Penalty is 16 crores 55 lakhs.
Yes.
interest is 19 crores 18 lakhs.
Yes.
Sorry, 86 lakhs. 86 lakhs. And my lords, the tax demand, total tax demand of HSD and non-HSD items is again 16 crores and 55 lakhs, which is, my lords, accumulation of 4.67 crores plus 11.88 crores. The total of this becomes 16.55 crores, because penalty your lordship saw is 100% of the tax amount.
Okay.
So the breakup, my lords, is
So this is 4 crore 67 lakhs is now the 15% of the total HSD.
That's right, my lord. That's right. That's right, my lord. And 11 crores 88 lakhs is, my lords, the entry tax on other items other than HSD. The total of which is 16.55 crores.
Okay. So that
And so my lords, when I file an appeal, I have to file an appeal by depositing 20% of the tax only. That's the mandate. So, my lords, now for all these 6 years, which your lordships find here in this chart, the total your lordship will make a note, my lords, is 44 crores, 44.06 crores, and 40.67 crores. A total of which, my lords, is 84.67 crores.
84.67 crores.
Yes, my lord, ballpark. Well, the exact figure I'll just give you, lordship.
This is 20% of the tax for all these years.
So this is the total tax. This is not the 20%. This is the total tax for all the years.
Total tax.
Yes, out of which, my lords, when I make 20% of this, I will have to pay about 17.5 crores as 20%. So I am willing, my lords, to deposit this amount in your lordship's court to only show my bona fides that I am not running away from a forum of an appeal only because of this amount. I am running away from the forum of an appeal only because, according to me, I should succeed at the first leg itself, and then I should have a fair trial and a fair appeal. So money is not the problem. The problem is...
Let us see the order disposing the preliminary objection.
Yes, my lord, let's see that. My lord, I'll just place it. My lord would kindly have... But before that, if your lordships permit, because half of the order is only a reiteration of what I have argued. So I'll just show your lordships one representation, a small representation filed by me, requiring the authority to decide my objection. If your lordship just kindly sees page 182 for a minute.
Yes.
This part, my lords, is in English, which I have filed. So just a small representation.
Yes.
My lord, if your lordships, it starts from page 182.
Yes.
Just second paragraph, if your lordship will see, I have given the reason why I have not obtained registration. I have said essentially that for the past 60 years, the law was in my favor, and therefore there was no requirement for a registration in this case. Now the Supreme Court has changed the law, but kindly come over to the next page, page 183.
Yes.
Then we refer, my lords, to our writ petition, second paragraph, where we say, accordingly, immediately after the decision of the Supreme Court, we filed a fresh writ petition number so-and-so before the Jharkhand High Court in terms of the liberty granted, together with a prayer for stay. The aforesaid fresh writ petition was taken away straight away for final hearing by the division bench of the High Court, and accordingly was heard at length on various dates. Matter was listed on so-and-so, and now posted for final hearing. Now, my lord, kindly see the second last paragraph. Further, it is submitted that section 11.5 contemplates a willful failure to apply for registration, which is conspicuous by its absence in the present case, which is evident from the aforesaid background facts. Furthermore, in your notice and the reply, you have not even alleged willful failure on our part to apply for registration. Therefore, the notice should be dropped. Then, my lords, kindly see the next page. It is to be noted that in view of the aforesaid, prior to the notice and the reply, the state of Jharkhand never took steps for registration, etc. Then kindly see the last paragraph.
Yes.
Still further, it is submitted to the first proviso to section 11.5 absolutely bars the proceedings under 11.5 after the expiry of 2 years from the expiry of the period to be dates. The notice in question being the period 15 15/11 to 31/3/2012 having been issued on 10/5 is hopelessly barred by time having been issued, etc., etc. Then, my lord, the next reply which we gave is almost identical, where we say at page 187, kindly see, third paragraph, at page 187, just one line I want to say, my lordship.
Which page? 180?
187, my lords.
Yes.
187. My lords will see, second paragraph, I say your proceedings are without jurisdiction. And then third paragraph, my lord, first line.
Yes.
The notice is raising certain preliminary objections as to the maintainability of the aforesaid notice pursuant thereto, which goes to the root of the matter and accordingly ought to be decided at the threshold before proceeding further in the matter. It is imperative to decide the aforesaid preliminary objections at the outset, inasmuch as if the notice succeeds on the aforesaid preliminary objections as per the notice, it ought to succeed on each preliminary objection. The whole proceedings would be redundant, meaningless, and without authority of law. Now, with this, my lords, I have filed certain other replies as well. But now, lordship may straight away come to the order which they purport to have passed on the 24th, which, my lords, your lordship will find at page 227.
257.
No, my lord, 227. 227. I'm sorry, my lords, the voice seems to be really bad. The audio. My lords, there is a typed copy also which we have annexed, which is also numbered at 227. But there is an English translation. You also may ignore that. That was done, I think, for my benefit. But the Hindi one is here at page 227.
Yes.
My lords will see, my lords, at 227.
Yes.
He has, in the first two pages, my lords, from 227 to 228, he has set out my case in the two representations which I read out to my lords.
Yes.
Then, my lords, at the foot of page 228, first then he quotes the definition of local area. Your lordship may ignore that for the time being. Kindly come to page 229. This is where his findings start. Middle of the page, page 229.
Yes.
My lords, my Hindi is slightly bad, so lordship will forgive me for that. I'll try and read it to the best of my possibility, my lord. भारती की ओर से पक्ष प्रस्तुत किया गया कि प्रवेश कर अधिनियम की धारा 11(5) के प्रथम परंतु के अनुसार काल बाधित हो गया है। यह भी पक्ष प्रस्तुत किया गया कि दिस इज नॉट अ केस ऑफ विलफुल फेलियर टू अप्लाई फॉर रजिस्ट्रेशन, क्योंकि ये अधिनियम so है। Then, my lord, what he does is he quotes 11(5) and then kindly turn over the page at 230.
Yes.
He refers, my lords, this. He says CA number 3581-3400 अन्य मामलों के साथ फादर स्टेट ऑफ केरला बनाम फादर विलियम के मामले में दिनांक 9/10/2017 को पारित किए गए न्याय निर्णय की कंडिका 145(3) में झारखंड न्यायालय के विरुद्ध दायर की गई सिविल अपील को स्वीकृत कर दिए जाने के फलस्वरूप माननीय झारखंड उच्च न्यायालय के निर्णय से भिन्न आदेश पारित करते हुए प्रदेश कर अधिनियम को इंट्रा वायरस माना गया है। तदनुसार झारखंड एंटी टैक्स कंजम्पशन ऑफ यूज ऑफ गुड्स 2011 की धारा 3 के अंतर्गत व्यवसायी की करदायिता स्थापित होने से 2 वर्ष के अंदर कार्रवाई प्रारंभ करने के 2 वर्ष के अंदर इसे समाप्त किए जाने का प्रावधान है। इस प्रकार काल बाधित नहीं है। So, my lords, he starts his point of limitation from 9/10/2017, relying on the decision of Father William, which, my lords, I have annexed as a part of my compilation in volume 2, the case law compilation, which your lordships will only see 3 paragraphs. This case has got absolutely nothing to do with the present controversy. Because my lord,
That is not part of the writ petition.
it is part, my lords, of the case law compilation, which has been circulated for your lordship consideration in volume 2 at serial number 1. Only 3 paragraphs, my lords, of that will show to your lordships that case has got absolutely nothing to do with the present case.
No, but the order which have been annexed, say at page 156.
That, my lords, is the order on which I am relying on, which is dated 22/3/2017. This is the order which we are concerned with. This is that order of 22/3. My lords, your lordship will see this. It starts at page. Lordship is referring to page 156.
156 is the order of 29th May 2017.
Yes. So now, for that, my lords, kindly first see the order of 22/3/2017, which is, my lords, at page, which is at page 124. It is at page 124. Yes, page 124.
Yes.
My lords, kindly see foot of the page, second last, civil appeal number. My lords have that. CA number 8275 of 2012 at page 124.
Just a minute. This order starts from 124.
Yes, so what I am bringing to my lord's kind notice is the second last entry on this page. Kindly see. CA number 8275 of 2012.
Okay.
This is the appeal by the state of Jharkhand against the order of this honorable court, right, my lords? Now this order actually, my lord, this order actually starts at page 128, and it gives, my lord, the entire history in 3 pages, leading up to the present situation.
Yes.
Now, my lord, if your lordships will kindly see at page 134 for a minute.
134.
134.
Yes, yes.
Now the three questions, my lords, are set out, which I just orally indicated to my lords. And in the next paragraph thereafter, your lordships, I'll just read it from here.
Yes, yes.
During the, may I place it, my lord, at page 134? Yes. Very good. During the hearing of arguments, counsel for both sides submitted that since the main challenge in the writ petition, which has been filed by the writ petitioners before the High Court, was predicated on the law laid down by the Constitution bench in Athyabari, the High Court essentially confined its decisions only on the compensatory tax theory as propounded in the aforesaid judgment, so that the High Courts looked at the issue by only keeping in mind the principle propounded in the aforesaid judgment and be decided as to whether the tax imposed by a particular statute is compensatory in nature or not. Thus, when other issues are to be dealt with, as indicated above, we find that in many cases there is no adequate factual foundation and there is no discussion in the impugned judgments as well. It is also agreed by counsel for both the sides that in the absence thereof, it may not be possible for this court to decide. Now, please see the next paragraph. According to us, in the aforesaid scenario, appropriate course of action would be to permit the appellants to file fresh petitions. That is, the SSEs were permitted to file fresh petitions by 31st May 2017, raising additional issues with necessary factual background. All these appeals are accordingly disposed of with the aforesaid liberty granted to the appellants. The interim orders passed by this court, which are continued in these appeals, shall continue till 31st May 2017. It will be open to the appellant to seek interim orders. We make it clear that the High Court shall deal with the interim prayers of stay on their own merits, etc. So, by this order, the matters were remitted to the High Court and assessees were permitted to file fresh petitions if they wanted by 31st of May. And
no, but here it is used the permit the appellants. Appellants was the state of Jharkhand.
So, Malot, that is, but the state cannot file a writ, Malot. It is because there were both appeals. There were cross appeals because they're not only concerned with Jharkhand here, they were concerned with Orissa also, where the matter had gone against the SSEs. Now, Malot, page 136 156, which your lordships pointed out, this is actually an extension of the timeline for the assessees because some of them could not file their petitions by 31st of May. So at page 156, my lords, your lordship will find this time is further extended till the 7th of July 17.
Right.
But that is for the assessees. Now, what is significant, my lords, is that insofar as the state is concerned, it could move ahead. It is for the assessees now to have gone to the High Court and sought whatever interim orders they wanted to. And in this case, my lord, there was no interim order which was issued by the High Court when we, I think, came back after this. Because they started the hearing straight away. Final hearing started straight away. So the point is that insofar as the state is concerned, my lord, its clock started to tick on the 22nd of March itself. What they seek to rely on is an order passed in the case of Father William, which is of 9th of October 17, which case does not deal with the present act at all. It deals with the Entry Tax Act of 1993, the Bihar Entry Tax Act 1993, as was applicable to the state of Jharkhand before this act came in. And we are not concerned with that act at all. So, my lords, had the assessing officer, that
judgment is part of the second volume.
That judgment is part, my lords, of the second volume, volume 2, first, my lords, first decision in that volume. And only 3 paragraphs I would show to your lordships will make it absolutely clear that that case has absolutely nothing to do with this case.
Yes.
May I show that, my lords, straight away?
Yes, yes, yes.
Yes. Would my lords kindly have, this judgment starts at page 1 and I will only show your lordship 3 paragraphs. Kindly see para 2.
Yes.
And it's a short para. These appeals relate to entry tax levied on goods imported from different countries and brought into the local area of the state. The legislative competence of the state legislature to impose entry tax on goods imported from outside the country entering into a local area of the state is questioned. Right, my lord? Now with this, if your lordships come straight to paragraph 30 at page 9.
Yes.
Now, my lords will see page 9, para 30. The heading is Civil Appeals Relating to State of Bihar.
Yes, yes.
Right, my lords? Now, over the page, if your lordship will see, first line at page 10, next page.
Yes.
First line. The state of Bihar has enacted the Bihar Tax on Entry of Goods into Local Areas Act of 1993. Right, my lord?
Yes.
Now, just below that, your lordship will see on the same page, Civil Appeal of State of Jharkhand.
Yes.
Now, kindly see the first 3-4 lines of para 33. The state of Jharkhand has filed an appeal against the division bench judgment dated 14/8/2006, delivered in writ petition number 5354, Tata Iron and Steel Company, Jamshedpur. Now, kindly see para 34. The division bench vide judgment dated 14/8/2006 allowed the writ petition holding that the provisions of the 1993 Act as adopted by the state of Jharkhand do not satisfy the requirement of Article 301 and 304. The state, agreed by the said judgment, has come up in appeal. Now, my lord, so therefore it is absolutely crystal clear that the only question which was being decided was, as the lord stated in para 2 and 3, whether when you import goods from outside the country, can the provisions of Entry Tax Act be imposed on such imports? And number 2, my lords, the act which they are considering is the 1993 Act of Bihar as adopted by the state of Jharkhand. And number 3, my lord, which is most important is, if your lordships kindly have the Act of 2011 with which we are concerned with, at page 64, the relevant part, under the present Act,
Yes.
under the present Act, my lords, the 2011 Act with which we are concerned with, this Act, my lords, I have annexed, but the relevant part is at page 64 of the paper book of the writ petition,
Yes.
section 2I, which defines the term importer. There is an explanation which has been added in that. I'll just read out the explanation, my lord. It says, for the purposes of this Act, import shall not include imports from outside the country. So, importers under this Act are in any case outside the ken of this Act. So the idea of only showing this to my lords is that this judgment has absolutely no connection with the case except that the assessing officer wants to latch on to it, knowing fully well that his proceedings are beyond the period of 2 years. And my lords, had he given me a proper opportunity, I would have explained this to him and would have pointed out that you are wrongly relying on this judgment. And we would not have troubled this court, my lords, had he accepted my submission.
So basically, one issue is of limitation.
Yes.
Second is of jurisdictional
That's right.
requirement of 11.5.
11.5.
There your argument is that the entire legislation was under challenge till the matter was remitted to the High Court again and we had to make a challenge.
Yes.
So long that was operating, there was no question of my willful act of non-registration.
And my lords, one more small fact, my lords, one more additional submission which I had made, which is actually fundamental to this case. Your lordship is aware, my lords, that if there is no allegation in the show cause notice of a willful failure, then, my lords, the show cause notice itself becomes bad. There, my lords, the Supreme Court has in more than one decision said so, that the foundation of the department's case has to be contained in the show cause notice. Your lordship recalls, my lords, under section 11A of the Central Excise Act, which gives an extended period of limitation to the department in cases where there is a willful breach or there is fraud or there is misrepresentation, to invoke a larger period of limitation of 5 years. In that case, my lords, the Supreme Court, while dealing with that section, has said that if the show cause notice does not contain such an allegation, then the show cause notice and the entire proceedings has to fall. My lord, that decision your lordships will find. I have also put in my second compilation at serial number 7, which is the case, my lords, of Toyo Engineering, Commissioner of Customs, Toyo Engineering, paragraph 16. I think, my lords, your lordships video is frozen, so I'm sorry, I'm not being able to. Okay,
No.
I see.
I think I'm able to see the live video of all of you.
I see. My lord,
We are looking at it.
Yes, very well, my lord, very well, my lord. I'm sorry, then in my system, I don't know why this
So,
So,
just wanted to know, today is the first hearing of this batch of writ petitions or?
I think, my lords, after the counter rejoinder has been exchanged, actually, after
First
counter
hearing.
rejoinder has been exchanged, first hearing, but the provocation, my lords, for filing an urgent application, which was earlier listed on the 11th, was that they have issued me now a notice saying that the recovery could not be made by the 18th.
Pardon?
My lords, they have issued a notice now through an additional affidavit, an application, saying that we should deposit this amount of tax by the 18th.
18th of April.
18th of April. Earlier, they had issued a notice, so, my lords, we had moved an application, but then, my lords, on 11th, there was no sitting, so therefore, the matters were moved for today. So we've moved. So now, after that, they extended the time and said, we are giving you time till the 18th. So I have also brought that on record, that they've given us time till the 18th.
So counter affidavit and rejoinder are there in all the writ petitions.
My lord, I am aware of my petition.
Yes, Your Lordship.
Miss
It
Sinha
is
will
there
be-
in all the
I
writ
see.
petition.
Very well.
So the state councils are ready for final argument today, or are you waiting for some other date? Mr. Deepak Dubey, Mr. Yadav?
My lord, we will be in a position to argue on any physical day, my lord. Today is the first date of hearing, my lord.
So 18th, my lord, if it meets with your lordship's approval.
No. We thought that it's the first hearing, other pleadings are not complete, but as you say, the pleadings are complete in
It is
all the
complete.
cases.
It is complete. It is complete.
And in fact, you are prepared and arguing it as a final hearing matter today. So if the state councils are ready to argue it today or otherwise they are asking for a time.
My lord, we are asking for time today, my lord, because Mr. Sachin Kumar will lead this in this matter, my lord, and he is already on legs in another court, court number 1, my lord, and perhaps he will not be able to free in the first half at least, my lord.
Then may I make a prayer, my
going on,
lord? Then may I make a prayer and a suggestion, my lord? May I make a prayer and a suggestion? Lordships may, my lords, may direct me to deposit that 20% before my lords in court. And subject to that, my lord, your lordships may give any date not convenient to the court.
So your third limb of argument was about the anti-dating issue.
The anti-dating, and that's important, my lord. If your lordship just quickly sees the order sheet with me, that is annexure 14. I have annexed the entire order sheet which I took, my lords, which I took from page 213, if your lordship sees.
Yes, 213.
My lord, yes, your lordship will see on the side, on the left hand side, your lordship sees a signature, and the date is marked there.
Just a minute.
Yes. So, kindly see 215.
215.
Yes. Now your lordship will see on the left hand column. This is there is a small signature and a date 22/2. This is the signature of the AO on the left hand column. And on the right hand, my lord, your lordship sees there is a noting called scene, and there is a
Yes.
signature.
Yes.
Now this is at page 215. Similarly, your lordship sees page 217.
217 is the next date.
Is the next date, my lords, 217. Again, my lords, on the right hand column, your lordship sees scene, and again my signature is there. Similarly, my lords, at page 219.
219.
Again, my lords, on the right hand column, scene and,
Yes.
and date. My lords, then it goes on like this, my lords. Then your lordship sees page 220. Then
Yes.
220. Then 223.
Yes.
Same, my lords. Then, my lords, 225. Again, my lord, same seen and marked.
Yes.
Then, my lord, your lordship sees 226. Same, my lord, seen and marked and signed. Right, my lord?
So on 220, page 226, the next date fixed is 24th November.
That's right. And kindly just see the number 2. details of purchase of high speed from outside the state of Jharkhand for the period so and so, and the details of use of HSD in manufacturing of iron and steel, Vicharopran Dinak Itna Nishchit. So these are the two details which he sought from us.
Yes.
These details, my lords, we produced through a letter which has been annexed, and it has been produced in the counter affidavit by the state.
Yes.
As annexure A to the counter affidavit, that letter I gave on 24th, page 20 of the counter affidavit. And my lords, then comes the order. Then comes, my lords, the order of 24th, the next date fixed, where your lordships find that there is no signature and there is no explanation in the counter also why the signature was not taken. Now I only need to show your lordships what they have said in the counter. What they say in the counter, my lords, in 3 paragraphs. If your lordship will just kindly see paragraph 12 at page 6. My lord, what they say in paragraph 12 at page 6 is
Yes.
that with regard to the statement in paragraph 17, it is stated that the petitioner itself has admitted in paragraph 16 that it has duly been intimated about the rejection of its representation by the respondent within notice dated 9/1/2020 so far as providing detailed order with regard to assigning the reasons of rejection is concerned, the respondent is under no obligation to provide a copy of the order suo motu. If the petitioner was at all interested in the detailed order, it should have applied for a copy of the said order. Now, my lord, at para 14 again, he says that with regard to the statement in para 20, it is stated as requested by the petitioner. The first written representation of the petitioner was disposed of on 24/11 in the presence of the representative of the petitioner, and thereafter the order of assessment was passed on 1/12. Now, my lord, if your lordships just kindly seize my rejoinder affidavit, I have placed on record an affidavit filed by one Jigyanshu Pandey, who is the person who was attending these proceedings, at page 19 of my rejoinder affidavit. But it's a short affidavit, kindly see para 2, second line. I further say that on the date of 24, when I attended the office of the adjudicating authority, except for filing the letter of 24/11, no other proceedings whatsoever were conducted by the AO in my presence. Neither did I sign in the order sheet of 24/11, nor the order sheet was drawn in my presence on the said day. This is evident from the record of proceedings. I further say that there is a known practice and procedure for taking the signature of the person who attends the proceeding. This is also evident from the record of the proceedings. However, no such practice and procedure was followed for 24/11 when I merely filed the aforesaid letter dated so and so. I further say that I specifically deny that the order, such as an order dated 24/11 for 11/12 was supplied to the petitioner. Subsequently, on 22/2/2021 was ever passed in my presence on the said date. I was not aware of such order dated 24/11 until 22/2/2021. When the order was first supplied to Tata Steel, I specifically assert that no such order dated so and so was ever passed in my presence or on that date on the file of the adjudicating officer. And my lord, just one small section which I wanted. Now, this business of their saying, my lords, that they are not obligated to inform me of this order or give me a copy actually, my lord, first of all, flies in the face of the principles of natural justice, the famous, my lord, decision of Bachittar Singh, where a similar issue came up, and the Supreme Court, my lord, has said that if you keep an order, prepare an order and keep it in your file without giving it to the other party, the very purpose of an order is defeated. I have annexed those decisions. But, my lord, before I bring your lordships to those decisions, kindly see, my lords, the rules, the entry tax rules, the rules, my lord, the relevant rule which I am referring to, my lords, is at page 91 of the writ petition, rule 17.2 and rule 17.4. My lord, this is the provision providing for what all the memorandum of appeal and revision must contain. Right, my lords?
Yes.
Now, my lords, kindly see sub-rule 2. The memorandum of appeal shall be accompanied by, now kindly see Roman 2, a copy of the challan in form JET 203 in proof of payment of the amount of tax in accordance with the provisions of subsection 1 of section 20. Now see 3. An appeal against an order of assessment or against an order imposing penalty shall be in form JET 601 and shall be presented. Now please mark this, within 45 days of the date of the receipt of notice of demand. So insofar as an appeal is concerned, the limitation starts from the date of receipt of the notice of demand within a period of 45 days. But your lordship knows, along with the notice of demand normally comes the order. But kindly see 4, which is very important for us. An application for revision before the commissioner shall lie in form JET 602 and shall be presented within 90 days from the date of the receipt of the order against which it is filed. So, the point is, if you don't serve a copy of the order, how does one file an appeal or a revision is the issue which arises. And this, my lords, straight has been answered by the Supreme Court. If any judgment is required for that proposition, my lords, in the list of case law, I will not, because these are very well settled principles, I will not waste the time of the court. My lord, in my compilation of judgments, what I have done is, my lord, like last time, I have put, my lord, the proposition for which I am citing the judgment and the paragraph number. So, if your lordship sees volume 1 of my case law compilation,
so we'll come to the compilations.
Very
One thing which I again wanted to clarify is the notice is of 10th May 2019.
Very well. Yes, my lord. Lordship is referring to the show cause notice. Yes, my lord.
Yes.
Yes.
So this show cause notice is within 2 years of the second order of 29th May 2017 at page 156.
It will be. It will be. But my respectful submission for your lordship's consideration is that order does not help the department at all. The order disposing of the appeal is of 22/3/2017. Right, Manoj? Now, after that, in that order as well as in the subsequent order which my lord just referred to, a liberty is granted to the SSCs to file a writ petition within that time. And, my lord, the interim protection which was granted, therefore, was of stay. That is only stayed. And, my lord, your lordship put a very pertinent question. Assume for the sake of argument that there was any order in favor of also. First of all, there is none. The department has not been granted any protection because they are to proceed for recovery. They don't have any protection from the court. Now, circumstances, your lordship recalls about that famous case of metal forgings and another versus Union of India. That unfortunately is not part of this compilation, but I'll just give you your lordship the citation. That is 2000 2 SCC, page 36, para 16 and 19. I will just, lordship may just give me the liberty to read out those 5 lines. which is very important, where, my lords, the Supreme Court in this case has said, my lord, this. May I just place para 16 because it's it.
Yes.
My lord, there is no protection in favor of the state. But I am assuming against myself for the sake of argument. Let us see what it says. Based on this interim order, the learned counsel for the revenue contended that the revenue could not have issued a show cause notice during the currency of the interim order. Therefore, by virtue of the explanation of Section 11A, the period of limitation gets frozen during the stay order. We cannot accept this argument either. It is a settled position in law that unless and until there is a specific injunction or stay granted by a competent court which restrains an authority from issuing the required notice merely because some interim order is made, the authorities empowered to issue such notice cannot refrain from issuing the required notice within the period of limitation, nor can they plead the existence of such an interim order as a defense against the plea of limitation. This court in Gopak Patel, Volkart versus CCE has held that where an interim order by the High Court merely stays the collection of excise duty, which the benefit of explanation of Section 11A excludes the period of stay, is not available to the revenue. The said judgment also holds that issuance of notice under 11A is a condition precedent to issue of notice. In that case, the interim order was issued in the following terms. And then they set out the interim order. And then again, para 19, my lords, they are saying exactly the same thing. So what they are saying is that supposing there was a stay of recovery, that does not help the department at all. They have to proceed as if there is no stay until and unless there is a stay of the proceedings full altogether. And that is not the department's case. That is not what the assessing officer is saying. The assessing officer is saying, I will go by that order in Father William. But all I am bringing to my lord's notice as a prima facie case only to show to your lordships is that if the assessing officer had given me a proper hearing, had I been in his presence, I would have been able to explain all this and we would not have troubled your lordship. I am only establishing my case prima facie to show to your lordships that I have something to say before the authority.
The objection or the preliminary objection that you had referred to which is at annexure.
Yes, I'll give you a look. Well, that is annexure 6 and annexure 9.
At page 182.
At page 182 and annexure 9 and page 187.
Yes. So we want to know that in an assessment proceedings, is it statutorily obligatory upon the assessing officer to deal with a preliminary objection and then pass an assessment order? It could not have passed a separate preliminary order. It could have dealt it with in the final assessment.
Yes, I see what my lord is saying. My lord, the answer is twofold. Number one, my lords, in those very representations which we have submitted, we have given a whole list of case law, at least 20 case law, which say that you should decide this. Quite apart from that, my lord, a very recent decision of the Supreme Court here, my lord, I just wanted to bring to your lordship's notice that decision, my lords, in fact, would address this issue. This, my lord, is a case Magad Sugar. This is a case of Magad Sugar versus the state of Bihar. This is 2021 SCC online, page 801. And my lord, this is in my volume 1 compilation. I have serial number 9. And your lordships may kindly take a note, my lord, of 3 paragraphs of that decision, which is, my lord, paras 11, 12, 18 and 25 to 29. I will show your lordship this decision, but I would straight away apropos what fell from the court, my lord. Let me first show your lordships this particular aspect which your lordships put to me. But this is, if your lordship sees, this is the decision. It starts at page 75. My lords have that page 75,
Volume 1.
volume 1, my lords. The name of
Yes.
the decision is Magad Sugar Energy versus
Yes.
State of Bihar.
Yes.
My lords have that. Now, this is a decision, my lords, by 3 honorable judges, a very recent decision.
Yes, yes.
And, my lords, I have given you the paragraphs which I am relying on are paras 11, 12, 18 and 25 to 29.
Right.
But, my lords, apropos what fell from the court, my lords, kindly see. First, I would want to show your lordship para 27, because if that meets with your lordship's approval, I need not trouble your lordship with anything else. Para 27 and page 83.
Page 83, yes.
Yes, please. Para 27. The above principle was reiterated by a three-judge bench of this court in Executive Engineer versus Sitaram. In that case, a show cause notice and provisional assessment order were issued to the assessee on the ground of an unauthorized use of electricity under Section 126 of the Electricity Act, and a demand for payment of electricity charges was raised. The assessee contended that Section 126 was not applicable to it and challenged the jurisdiction of the taxing authorities to issue such a notice before the High Court in its jurisdiction. The High Court entertained the writ petition when the judgment of the High Court was appealed before this court. It was held by that the High Court did not commit an error in exercising jurisdiction in respect of a challenge raised on the jurisdiction of the revenue authorities. The court made the following observations. Now, this is what I am relying on.
Yes.
Should the courts determine on merits of the case, or should they preferably answer the preliminary issue or a jurisdictional issue arising in the facts of the case and remit the matter for consideration on merits by the competent authority? Again, it is somewhat difficult to state with absolute clarity any principle governing such exercise of jurisdiction. It will always depend on the facts of a given case. We are of the considered view that the interest of administration of justice shall be better subserved if cases of the present kind are heard by courts only where they involve primary questions of jurisdiction or matters which go to the root of the jurisdiction, and where the authorities have acted beyond the provisions of the Act. It is argued, and to some extent correctly, that the High Court should not decline the exercise of its jurisdiction merely for the reason that there is a statutory alternate remedy available, even in a case falls in the above stated cases. Now, kindly see only the bold part actually, which is relevant. In other
Yes.
words, if exercise of jurisdiction by a tribunal is ex facie appears to be an exercise of jurisdiction in futility, or for any stated reason, then it will be permissible for the High Court to interfere in exercise of jurisdiction. The issue is no longer res integra. And then, my lords, kindly see the last paragraph, paragraph 33. We are of the and this was a case, my lords, where the assessment order was challenged before the Supreme Court under the Electricity Duty Act of 1948. We are of the considered view that the High Court made an error in declining to entertain the writ petition, and it would be appropriate to restore the proceedings back to the High Court for a fresh disposal in order to facilitate a decision on demand. We have recorded the broad submissions of the parties on merits, but leave the matter open to a fresh evaluation. So, my lords, this is
yes.
This is the approach, my lords, if I may say so, which I am, my lords, commending for your lordship's kind consideration, that there are two ways of approaching this matter. One is, my lords, that this honorable court itself considers the issue because it's a jurisdictional issue. The other is, my lords, as the Supreme Court says, that they broadly lay down the contours of controversy and what each side is arguing, and allowed the High Court in this case, and your lordships will perhaps allow the department in this case to consider the matter afresh in the light of what has been stated here. So, my lord, this, my lord, is actually also something which goes to, my lords, avoiding multiplicity of proceedings and abuse of process of court. Because if a proceeding is stillborn or a nullity to start with, there is no, my lords, fun in going through the entire process. That's what the logic seems to be.
Very well.
So,
yes. Anything else, Mr. Gulati, for the present?
No, my lords, I think your lordship has been very patient and deeply
Yes,
obliged.
Mr. Dubey, you and Mr. Yadav wanted for a physical hearing.
Yes, Your Lordship.
And where is the notice, Mr. Gulati, in which there is a deadline of 18th?
Yes, my lord. Because there is an interlocutory application which has been filed.
In all the writ petitions?
In all the writ petitions, because these are identical dates, same date of notice and same dates of orders. So, my lord, this is my lord's annexure. This is annexure 1 to the IA at page 10.
That is deposit up to 22nd March 2022.
So that I think is the date for appearance. Huh? Sorry, 18th.
No, thereafter.
इसमें राशि का भुगतान करते हुए लिखा हुआ है।
Sorry, just a second. I think I've given your lordship the wrong page. This was the initial date. No, I'm sorry, this is the initial date. There is another IA which they have filed, my lords, which is dated, where the notice is dated 23/3/2023, and now they've set the date of 18/4. Mr. Gadodia, could you please indicate the IA number, if possible, for the lordships?
There is no another IA file, but sir, this notice itself was the second date has been given on 18/4.
I see.
So that reminder is not on record.
Yeah, that reminder is not on record. I'll
Not on record.
send it to the group.
Acha, then I stand corrected, my lords. I was given to understand that probably it was, but then it is not. Huh? But I don't know whether your lordship will be able to see it from here or not. Screen share, but Sumit, do you have it online?
No, we believe whatever you're saying, so it's not that.
Well, it is a notice, well, bearing number 7225 dated 23/3/2022, and it says fixing the date of 18/4/2022 for that purpose.
Deposit by 20?
Deposit by 18/4.
18/4.
18/4/2022. So, my lords, if the state is seeking time and if it is convenient to the court, my lords, then may I request 18th, if possible, if your lordship has.
On that we will see first.
Very well, very well. I leave it to the court. I leave it to the court.
Brother, I'm just calling you for a while.
ओह मेरा फोन तो है, ले आइए फोन मेरा रूम से।
लिखिए। The challenge to the virus of Jharkhand Entry Tax on Consumption or Use of Goods Act 2011 was upheld by this court by judgment dated 3rd April 2012 passed in WPT number 5696 of 2011. Stop. After the decision of the apex court in the case of after the decision of the apex court in the 9-judge bench constitution bench judgment in the case of Jindal Steel Limited, within bracket 2 and another versus state of Jindal Steel Jindal Stainless Steel Limited and another versus state of Haryana and others 2016-11 scale page 1. The civil appeal number 8275 of 2012 and other analogous appeals preferred by 8275 of 2012 preferred by the state of Jharkhand and other analogous appeals were decided by a division bench of the apex court by judgment dated 22nd March 2017 within bracket annexure 3. होल्डिंग एज अंडर, ये पेज 133 का लास्ट पैराग्राफ से लेकर के एंड तक कर दीजिए। The SSEs were granted liberty to approach the jurisdictional high court to file fresh petitions by 31st May 2017, raising the issues three kinds of issues taken note of in the judgment of the apex court as above, with necessary factual background or any other constitutional/statutory issue which arise for consideration. Stop. By an order dated 29th May 2017, the interim orders which were passed by the apex court were continued in those appeals till July 7, 2017. Stop. Thereafter, the present SSE has also preferred a fresh writ petition, that is WPT number what is that number of that case?
3884. 3884
3884 of
2017.
2017, which is pending consideration. Stop. The present challenge ऊपर में ऐसे कर दीजिए, लेट ये सारा को टैग कर दीजिए, WPT सीरियल नंबर 50 से लेके 55 तक. Let all these petitions be tagged together as they raise common issues relating to assessment proceedings under Jharkhand Entry Tax on Consumption or Use of Goods Act 2011. Stop. इसके बाद जहाँ लिख रहे थे वहाँ लिखिए. The present writ petitions relate to quashing of the assessment orders and review assessment order for different assessment years starting from 2011-12 till 2017-18.
Yes, Your Lordship. Yes, Your Lordship.
Yes, Lord.
Under the Act of 2011. Stop. Pursuant to the assessment order, demand notices have been issued. The assessment orders, the assessment orders of the common date, that is 21st December 2020, were revised by the impugned assessment order dated 24th March 2021, which is also common in all the writ petitions.
May I point out?
Achha.
No, only the first matter.
Common.
Oh.
No, Your Lordship, in the two matters only the date are different, rest all the matters the date are similar.
So then give the dates. The rejection
Yes,
of
Your
the
Lordship.
preliminary objection order is same in all.
No, Your Lordship, that is also different.
Then you should have given the complete chart of.
Just now I will be giving, Your Lordship, just now.
Give it so that we can adequately modify in our opening paragraphs.
Yes, Your Lordship.
Demand notices. The respondents have issued demand notice such as one enclosed in IA number 2339 of 2012, dated 3rd March 2022, bearing number 5408, asking the petitioner, IA number so and so in WPT 1953 of 21, asking the petitioner to deposit an amount of rupees 52 crores 98 lakhs 46,636.00 by 22nd March 2012. Similar notice has been issued in all the writ petitions.
Yes, Your Lordship.
IAs are also there.
Yes, Your Lordship. IAs are also there. Date are also same in all the notices.
Similar notice of the same date have been issued in respect of other assessment years. ये इसको कर दीजिएगा 2011-12. Other assessment years, which have also been brought on record through respective interlocutory applications in the analogous writ petitions. Stop. Senior counsel for the petitioner has argued on the lead matter WPT number 1953 of 2021 as common issues of law and fact are involved. in all the writ petitions. Stop. He has also brought to the notice of the court that a reminder notice has been issued on 23rd March 2022, bearing number 72225, asking the petitioner to deposit the total amount as indicated therein by 18th April 2021, failing which 22 coercive steps would be taken if no interim stay is obtained, if there is no interim order in their favor. Stop. The grounds of challenge are primarily threefold. Small one. The first and the second ground of challenge both stem out from the provisions of section 11.5 and the proviso thereunder. Stop. As such, of the Act, as such, section 11.5 is quoted hereunder. As section 11 is quoted hereunder in toto. Stop. Learned senior counsel for the petitioner has urged that no satisfaction has been recorded by the prescribed authority showing reasonable grounds to believe that the SSC or any person other than a registered person has willfully failed to apply for registration, though being liable to pay tax, and is thus required to be proceeded under this section, under the section 11.5 for assessment of tax, penalty and interest as well. Stop. The requirement of alleging specific acts of willful failure on the part of the petitioner is completely lacking in the notice dated 10th May 2019, so cause notice dated 10th May 2019. Stop. For the period up to 22nd March 2017, that is the date of judgment of the Apex Court in Civil Appeals number 8275 of 2012, the Act of 2011 was not on the statute book as having been held ultra vires, the constitutional provisions. Stop. The initiation of proceedings therefore suffers from erroneous assumption of jurisdiction. Stop. Which goes to the root of the matter and is amenable to writ jurisdiction as is also held in the recent judgment of the Apex Court in the case of Magad
First volume, ninth case, sir.
Magad Sugar and Energy Limited versus State of Bihar and others, 2021 SCC Online Supreme Court 801, para 25 to 29. Second, small 2. The proceedings initiated under show cause notice dated 10th May 2019. This is the same date in all the assessment proceedings of show cause notice,
Show cause notice date is same, Your Lordship.
which is same in all the writ petitions covering different assessment years, is barred by limitation in view of the proviso to subsection 5 of section 11 of the Act, being after the expiry of 2 years from the period to which it relates, reckoning the start of limitation from the date of the judgment of the Apex Court in Civil Appeal number 8275 of 2012, that is 22nd March 2017. Stop. The respondents in their counter affidavit have wrongly placed reliance on the date of starting of the limitation period from 9th October 2017, relying upon the judgment of the Apex Court in the case of Ferdinand Williams, State of Kerala and others versus Father William Fernandez, etc., 2017 SCC online, Supreme Court 1291.
Paragraph 26, Your Lordship.
Learned counsel for senior counsel for the petitioner has referred to paragraphs
30 and 33.
2, 3, 30 and 33. 33, 34.
page 9 and 10. Paragraphs 30 and 33 dealing with the civil appeals of the state of Bihar and state of Jharkhand and concerning the Bihar Tax on Entry of Goods into Local Areas Act 1993. Stop. According to the petitioner, the said judgment has no application to an assessment proceedings under the 2011 Act. Stop. To make things more clear, learned counsel for the petitioner has also referred to the definition clause of import under section 2I. Explanation to the definition clause section 2I of importer within inverted comma, which reads as under. Page 64 separately. The decision in the case of William Fernandez related to a question on the applicability of the State Act on imports from foreign countries. Stop. The present Act of 2011 has not included consciously, has by the explanation consciously excluded imports from outside the country from the purview of the Act. Stop. As such, the initiation of proceedings, assessment proceedings, is barred by limitation and void in law. Stop. Learned Senior Counsel for the petitioner has then referred to the reply of the petitioner to the show cause notice dated 10th May 2019 at Annexure 6 dated 10th June 2019, where the petitioner had raised preliminary objections to the initiation of the proceedings. Stop. It has been categorically stated that the order dated 24th November 2020 rejecting the preliminary objections of the petitioner are antedated, since the same do not bear the counter signature of the representative of the petitioner company and is a significant departure from the consistent practice followed in all such orders passed in the same proceedings on different dates, such as 215. Orders dated 20th January 2020, 27th January 2020, 27th February 2020, 14th February 2020, 24th February 2020, 5th March 2020, 14th March 2020, 17th August, 26th August 2020, 6th October 2020, 9th October 2020, and 9th November 2020, the date preceding the date of the rejection of the preliminary objection in the that is 24th November 2020. Stop. The order rejecting the preliminary objection was never served upon the petitioner to enable him to avail of the revisional remedy under section 21 of the Act within the stipulated period of 90 days. Stop. Instead, in fact, the assessment order was passed immediately thereafter on 1st December 2020, which merged the order dated 24th November 2020 into it, leaving the petitioner with no opportunity to avail the alternative remedy of revision. Stop. Learned counsel for the petitioner submits that the order rejecting preliminary objection came to be known to the petitioner only after issuance of the certified copy of the entire order sheet. Stop. The proceedings have thus been vitiated for lack of fairness on the part of the assessing officer. Stop. For all these reasons, the writ petition is maintainable under Article 226 of the Constitution of India and fit to be allowed by remanding the matter to the assessing authority for taking a decision afresh after taking into account all the points of law and facts with supporting documents adduced by the petitioner. Stop. The senior counsel for the appellant has submitted that under Section 20, paragraph of the Act of 2011, any such appeal is entertainable by the authority only upon deposit of 20% of the tax assessed or such amount of tax as the appellant may admit to be due from him, whichever is greater. Stop. Learned counsel for the petitioner has referred to page 182 of the writ petition containing the breakup of the demand for different assessment years starting from the year 2011-12 till 2017-18.
Page 233, my lord.
That is page, what is that page?
233, my lord.
232.
233.
230. Page 233. Stop. It is also submitted that in the present writ petition, WPT 1953 of 2011, 21, the assessment order contained an apparent error on the record as the entire turnover of HSD oil was assessed to tax, though only 15% of the value of the transaction on HSD oil were liable to tax under the Act of 2011. Stop. This being pointed out by the SSE, the revised assessment order was issued on 24th March 2021. Stop. The breakup of the tax indicated at annexure 15 at page 233, including that on HSD oil and other than HSD oil, would come to 84.73 crores. and odd.
Lord, may I just point out, I've taken the exact figure now, 84.74.
84.74.
74, yes.
74 crores. Then senior counsel for the petitioner submits that being conscious of the riders of statutory deposit and while preferring an appeal under section 20 of the Act, the writ petitioner is ready and willing to deposit the 20% of the tax amount as assessed for the respective periods 2011-12 till 2017-18. That is about how much?
16.94.
16.9.
16.94 crores approximately.
16.94 crores before this court as a condition for interim protection, which, however, may be kept in an interest-bearing account. Stop. Para. Learned senior counsel for the petitioner based on the aforesaid submissions, prayed for an interim protection. Stop. Learned counsel for the pleadings, though counter affidavit and rejoinder affidavit have been filed in all the writ petitions. Stop. However, learned counsel for the state has prayed for time to address the court on the part of the respondent state. Stop. On any convenient date when the court is functioning in physical mode. Stop. As prayed for, list the case. As prayed for on behalf of the respondent state, list the case on these cases on tenth of May 2022. Sorry, or 22. Stop. Subject to deposit of an amount of rupees 17 crores before the learned Registrar General of this court. Within what time?
Within 12 days.
So before at least 18th April you should deposit.
Very well. Actually, there are 3 days which are bank holidays. That's why I was making that request. 3-4 days are a bank holidays in between.
Pardon?
3 or 4 days there are bank holidays, starting from the 13th. Okay. That's why I was making that prayer.
By 19th of April? By 20th of April. By 20th of April 2022, no coercive steps shall be taken against the petitioner in respect of the impugned demand notices in the respective writ petitions relating to the respective assessment years. Stop. The amount so deposited shall be kept in an interest-bearing account by the learned Registrar General.
Yes.
Amrita, you give the breakup of the dates.
May I submit, Your Lordship?
Yes.
Yes, Your Lordship. One matter, serial number 6, a direction may also be given that this matter may also be tagged along with the batch matters, Your Lordship. Serial number 6.
That I have already indicated in the morning. No?
Much
after removal of defects.
That means
yes, Your Lordship. Much obliged.
That also relates to the same tax period.
Same tax period, Your Lordship, that relate to 12/30.
You please give a chart containing each writ petition, the tax period, the total demand dates, and the relevant assessment orders or the annexures of those demand notice.
I have prepared it, Your Lordship. Just now I will be handing over to the court master.
Very well, very well.
Much obliged.
Obliged.
Obliged, Your Lordship.
Okay, thank you. ये सब जरा इसमें डाल दीजिए.
Item 56, WPP number 214 of 2020, Mr. Sumit Garodia for the petitioners, Mr. Amit Kumar, Mr. P.S. Pati for the response.
May it please your lordship.
This is same GST on royalty. Sorry, GST
Yes,
on royalty.
GST on royalty, my lord. Yes. Your lordship had earlier granted stay on the basis of the order passed in Lakwinder of the Honorable Apex Court, my lord.
Yes, yes.
And then I brought to your lordship notice that that writ petition which was there before the Supreme Court was
So this
not.
will get tagged with the batch matters of today.
Yes, yes. It will get it will get tagged, my lord. Correct. In fact, I've given a chart in the batch matters, which includes this matter also, my lord.
Compilation.
In fact, my lord, this matter is pending across various honorable high courts. I have given various orders.
Anywhere it has, the High Court has stayed the GST on royalty.
Yes, all the high courts have stayed, my lord. Some on the basis of Lakwinder Singh originally, but it is only on the original order itself, which was passed in Udaipur Chamber of Commerce.
Not on fresh reconsideration.
Yes, not on fresh no. If your lordships may see the first order, Guwahati High Court, that's an order which is passed, my lord, on a independent consideration. The first order. In fact, this is where the order which is.
No, Mr. Garodia, your compilation is good, but if you could have summarized each of the orders in 2 lines by a short compilation, then it would have been easier for us to go.
I'll do that. I'll do that, my lord. I'll do that.
So even the judgments which you have relied upon in Roman 2, Roman 3 onwards on different aspects.
Yes.
That would help us instead of going through all.
Yes, I'll prepare a very short note, my lord, a 2-page note giving reference of the page number of the judgments and the interim orders passed.
The exact ratio in italics which you are relying from that judgment.
I'll do that, my lord.
So then we keep it on any other day?
Yes, my lord. Can be passed over for the day if your lordship it would come on 18th.
Next Monday, maybe there might be.
Any day subject to your lordship's board, my lord, and convenience.
Next week, any day, that will be.
कब बोल रहे हैं, brother?
Next week, any day.
हाँ, वैसे तो this is not a very longish matter now.
Yes.
Next Wednesday को करते हैं? ये नहीं, physical day.
Physical day में subject to your lordship's pleasure. Okay.
Wednesday is slightly beyond, perhaps.
So let it be on Wednesday, my lord. I'll give it much in advance.
Okay. Nothing much to argue in this case by the court.
Wednesday को फिर कर.
Yes, that will be okay.
20th April 2020.
Right.
ये item 56 को tag कर दीजिए. Let it be tagged along with the batch matters, starting from item number 11.
10.
Stop. A revised, a compilation of judgments has been submitted by learned counsel for the petitioners, Mr. Sumit Garodia, today morning itself. Stop. He would be submitting a short synopsis. Yeah, I need not say that.
Yes, yes, I'll do that, my lord.
Let the matter appear on 20th April 2022. These matters.
Obliged.
Now there is one hearing. Mr. Indrajit Sinha, you are there in this first appeal.
Hearing matter, I am there, my lord.
Yes, yes. No, there is one first appeal in which Mr. Indrajit is an amicus.
Lordship, I'll just ask my senior to connect if it could be kept after, say in second half, Lordship.
Okay, wait, let us see. Mr. Garodia, what about this last hearing matter?
My lord, it can be passed over for the day, subject to your lordship's pleasure.
Let it be passed over for the day. I do not want to adjourn it and then it go out of list because we have agreed to hear it.
Yes.
Only I want to give me a bit more of breather time so that I don't have to sit long.
Yes, yes, my lord. We fully, my lord.
So then it is simply passed over for the day.
Obliged, my lord. Much obliged.
And item 3, Ms. Anjali,
Yes, Lordship.
we have gone through the written notes.
Yes, Lordship.
Had Mr. Indrajit Sinha been here, I would have advised him to incorporate one aspect into it.
Yes, Lordship.
That was, you see, at the end, the learned amicus has summarized the line of arguments or a line of submissions
Yes, Lordship.
to the effect that an expansive construction in the entire context of the statute, the aims and object of the statute has to be given. So far, so good. Now we have to give a strict construction to section 24.
Okay, Lordship.
So on the one hand, we have to give a expansive and liberal construction of the Total Family Courts Act in the light of its aims and objectives and expeditious disposal, etc. And then a restrictive construction. So one or two decisions on this point as to, in such circumstances, like in an exemption notification or a notification giving an incentive, the first line is to give a strict interpretation to that. And once an enterprise or a body comes within the strict interpretation of that exemption notification, then the benefit of that notification has to be given liberally in favor of that. So, not exactly on those lines, but then when the aim and object of the act is a wider one, where expeditious disposal, keeping into mind the beneficial provisions of the FCA, have to be given effect to. Strict interpretation of the appeal section, so far as it relates to interlocutory orders. To that extent, any more judgment, if you people can find out, you can add to it.
Yes, Lordship.
Rest of it is fine. So let it continue then, this one also on next Monday.
Sure, Lordship.
That's all about for the day. Brother, you take
Okay,
leave.
sir. Yes, sir.
Exactly 1:30.
Yes, sir.
Thank you. Thank you.
Thank you.